All rise. This honorable court is now in session. Please be seated.
Good morning again. We're about to start our third case this morning. Justice Campbell has recused herself on this case, as you can see by her absence this morning. You may call the next case.
Ernest Falls et al. Versus Mark Goins et al.
Good morning. May it please the court. I'm Bill Harbison of the Nashville Bar, and I'm one of the lawyers here representing Mr. Falls, who is the appellant in this case. 87. He's had no other criminal convictions. In 2020, the governor of Virginia gave him a full grant of clemency that restored his rights of citizenship, including his right to vote. He attempted to register to vote in Granger County, Tennessee, and was denied because he had not proved that he did not owe any Virginia court costs or restitution from the 1986 conviction. And the payment of such costs or restitution was not a condition of his grant of clemency by the governor of Virginia. The sole issue that this case presents is whether Mr. Falls has been unlawfully denied his right to vote in Tennessee. The facts are undisputed, stipulated, and we note at the beginning that the Director of Elections initially agreed with Mr. Falls' position legally that he was entitled to vote, and then changed its position to what we are now dealing with in this case, which is trying to make our way through a set of statutes, really two different sets of statutes, to reach the analysis of whether or not he's entitled to vote in Tennessee. This is a case of first impression in this court to interpret these statutes that deal with whether someone who's been convicted of an infamous crime can vote in Tennessee. And the court's analysis should be guided at the outset, of course, by the Tennessee Constitution, which, as we set out in our brief, grants all citizens the right to vote, even people who've been convicted of crimes. And the only exception to that is that the Constitution in Article 1, Section 5 states that the right to vote may be denied, quote, upon a conviction by a jury of some infamous crime previously ascertained and declared by law, and judgment thereon by a court of competent jurisdiction. Now, we're not operating in a vacuum here. There are prior cases from this court and from the Court of Appeals that clarify the proper constitutional analysis that this court should bring to bear on this case. And those primarily are the Crutchfield case and the Gaskin case. What those cases make clear is that disenfranchisement, that is, operations that would remove someone from the right to vote, is not a self-executing proposition. Our Constitution requires that the legislature pass a law, first, that declares what crimes are infamous, and secondly, that pass a law that states that the right to vote is removed upon conviction of such a crime. The Crutchfield and Gaskin cases teach us that we start with the analysis to say, is there a law that removes the right to vote? Is there a law about disenfranchisement? And what we suggest to the court is that there's really only one statute in Tennessee that addresses the loss of the right to vote for an out-of-state conviction. And that statute is Section 2-19-143(3). Now, this statute is found in the voting section of the code. It's about elections. And it states, and the plain text of this statute is really what we suggest the court's beginning analysis should be and ending analysis should be. This statute states, quote, no person who has been convicted in another state of a crime or offense which would constitute an infamous crime under the laws of this state, regardless of the sentence imposed, shall be allowed to register to vote or vote at any election in this state. So I'll stop there to say this is a statute that makes a criminal conviction in another state of a crime that would be infamous in Tennessee the type of conviction that would remove the right to vote. But the statute does not stop there, and this is the critical part. The statute goes on to say, unless such person has been pardoned or restored to the rights of citizenship by the governor or other appropriate authority of such other state, or the person's full rights of citizenship have otherwise been restored in accordance with the laws of such other state, or the law of this state. Now that unless part of the statute is what's critical in this case, and we think the analysis can begin and end with that unless phrase from this statute, because Mr. Falls is stipulated to meet the criteria of the first exception, which is that he's been restored to the rights of citizenship by the governor of Virginia. He could, had he not gotten his full restoration of rights from Virginia, he could have followed another pathway set out in this statute, which is to follow some other restoration process in Virginia, or he could have followed a restoration process under Tennessee law, which was a change that was added to this statute in 1983. This statute was passed, for the court's reference, in 1981. It's applicable to him, to Mr. Falls. It's the only statute in our state that addresses the disenfranchisement of a person for conviction of a crime in another state. We don't have another statute that does that. Its plain language does not take away the right to vote from a person whose rights have been restored by the governor of another state. So our legislature chose, one way to think about it for the court is our legislature chose to give full faith and credit to convictions of a crime in another state. They chose to do that, to make that a potentially disqualifying event. But our legislature simultaneously chose to give full faith and credit to a restoration of rights in another state. So that if Virginia, for example, in this case, had fully restored Mr. Falls' rights, which it has, then on its face, he does not fall into the class of people who have been disenfranchised. A person who has not been disenfranchised does not need to follow any other procedure. Our Constitution teaches us that. Our Constitution says he has the right to vote unless there's a statute that takes it away.
So, Mr. Harbison, is your position that even when your client moved here in 2018, prior to the commutation by the Virginia governor, that he was not disenfranchised at that point?
No, at that moment, when he first moved here in 2018, he had been convicted of a crime in another state.
So you would agree
he
was disenfranchised, or was ineligible to vote in Tennessee up until 2020 when the commutation was
That's
started.
right, Your Honor. That's right. And nothing in any of the statutes, and I will talk about the restoration statutes in just a moment and how they may interact. We think they don't interact with the deprivation statute that I'm talking about now.
Can I ask you?
Oh, yes, of course.
Just reading the language of this provision that you have focused us on, it says that no person under these circumstances shall be allowed to register to vote or vote unless.
Yes.
Are you asking us to read this to say if this person meets one of these last criteria, they must be allowed to register and vote? Okay.
Yes.
That's not really how the language reads, but you are asking us to read it that way, right?
I want you to read it that way because
there's a difference between saying something negatively, shall not be allowed, and positively.
And the answer to the court's question really is to go back to the state constitution, which teaches us that everyone has the right to vote.
Well,
as a starting point.
It does speak, though, to whether the legislature can put other conditions on allowing somebody to register.
For conviction of an infamous crime.
Yes.
That's right. And so since this is the only statute that removes the right to vote, because it starts with no person can vote. I agree, the language is plain, but it then goes on to say unless that person meets another exception, and there are 3 exceptions in that statute. And the first one is a plain exception that says we're not taking the right to vote away if that person has been restored in another state.
Mr.
Tennessee chose to do it that way.
Excuse me, to follow on Justice Bivens' question, would your argument be stronger if he had been restored to his rights in Virginia many, many years ago and been voting there all this time before he moved to Tennessee?
Well, I think it would be the same analysis under this statute, Your Honor, but I think that the fact that it could have been that makes clear that what Tennessee has chosen to do in the choosing about who is deprived of the right to vote by virtue of a conviction, we look to the law of that other state for whether there's been a conviction. And we look to the law of that other state to see whether there's been something that happened that restored the rights. And so the relevant point in time, we would suggest, is not when someone moves to Tennessee. It's when somebody registers to vote.
Is the record clear that had he remained in Virginia, he could be voting?
I'm sorry?
Is the record clear that had he remained in Virginia,
yes.
he could be voting? No question about that?
No question about it. Okay. That's not even a close call. It's stipulated that he has the right to vote in Virginia. And I don't think the temporal notion of when someone moves to this state is anywhere supported in the text of any statute. It's really, again, we focus, the first question needs to be, at the moment he registers, has the right to vote been taken away from him? That's the right question.
I would like to hear you address the issue, and this is probably in your argument, and you haven't gotten to it yet, but the dissonance between a person who is convicted of an infamous crime in Tennessee versus someone so convicted in another state.
So I'll try to address that, Your Honor. A person who's been convicted of an infamous crime in Tennessee can avail himself or herself of a process to restore the right to vote. And that's in the criminal procedure statutes found in Title 40. And it would be 40-29-201 and following. And those are a set of statutes that were enacted in 2008. So some 25 years after the enactment, I'm sorry, I said 2008. I think it's 2006, I'm sorry. They were enacted in 2006. And they were intended, those statutes were intended to provide an administrative means by which someone who had been convicted of a crime could avail themselves of a process to have their rights to vote restored. The way we want the court to frame this issue, we suggest the court should frame the issue, is that the first question is there a deprivation statute that applies? That would be the Title II statute. And if a person has been deprived of the right to vote and they need to go through a restoration process, it would be the Title 40 statutes, 40-29-201. That's a process Mr. Falls could have availed himself of had he needed to. In other words, after he moved to Tennessee and he was convicted of an infamous crime in Virginia, a pathway that he would have had, and it says so in 2-19-143.3, is to have his rights restored pursuant to the restoration process, administrative process set out in those statutes in Title 40. But a fundamental bedrock principle of this case is that a person who has the right to vote does not need to have those rights restored. A person who has the right to vote does not need his rights restored. And we know that the Title 40 statutes, 40-29-201 and following, we know that they are only restoration statutes. We know that they are only intended to provide a pathway to have rights to vote restored because they were considered by the Sixth Circuit Court of Appeals of the United States in the Johnson versus Bredesen case in 2016. Now, that's an important thing worth spending a little bit of time in oral argument to discuss because there was a constitutional challenge brought 240-29-201, and in particular to the financial requirements that the state now says have tripped up Mr. Falls. That is, to prove that he hasn't paid court costs or hasn't paid a fine or doesn't have unpaid child support obligations. Those were conditions that the legislature placed for restoration of the right to vote in 40-29-201. In other words, a person applying for the right to vote needs to prove that they don't have those financial obligations or that they've been satisfied. The Johnson versus Bredesen case challenged the constitutionality of those financial conditions to the restoration process based on equal protection, based on due process concerns, privileges and immunities concerns. The Sixth Circuit held that those statutes passed muster, those financial obligations passed muster, precisely because they did not deprive anyone of any rights. They did not deprive someone of the right to vote. They dealt only with someone who lacked the right to vote, seeking to have those rights restored. Since it was a restoration only, since those statutes were dealing only with a process to restore voting rights, they didn't take away voting rights, and therefore the court could apply a rational basis level of scrutiny, which the court found the state had passed. And the state did not have to pass strict scrutiny. The statute did not need to be subjected to strict scrutiny, which, had it been a voting deprivation statute, it would have had to be subjected to. This is very significant because now what has happened below, and what the state is asserting now, is that somehow the restoration statutes have blended into the deprivation statute in 2-19-143.3 and impose an additional requirement on Mr. Falls. But nothing in any of the statutes suggests that that's right, and this sets those statutes in conflict with each other. And we suggested the court would essentially do away with the exception for a full restoration of rights under 2-19-143.
Mr. Harbison, this is Justice Lee.
Yes.
If what you're saying is correct, why would 4029-202 contain a provision for a person receiving a pardon? Why wouldn't a person who gets a pardon automatically only go under 43B? Why would there be a restoration provision for a person receiving a pardon in 202?
Your Honor, we would suggest that when that statute was passed, they used the word pardon in that context, making clear that this was only dealing with people who were seeking their rights restored. And pardon is a word, as I'm sure the court knows, that can be used in a lot of different ways. But pardon can also mean commutation of a sentence, the termination of an end of a sentence. It doesn't necessarily take with it a full restoration of rights, including the right to vote. If a person received the kind of pardon that fully restored the rights of citizenship, then a Tennessee resident would be able under 2-19-143.1 to vote. They wouldn't need the restoration process, just like Mr. Falls doesn't need the restoration process. But a pardon, as used in the court's question in 40-29-201, does not say a pardon that restores all rights. It simply says a pardon in a list of things like you have served the rest of your sentence has ended. And so it's definitely dealing with someone who still doesn't have the right to vote and needs to have that right restored.
So you're basically saying that subsections 1 and 2 of 2-19-143.3 are self-executing?
Yes.
That as soon as the governor, be it of this state or another state, signs that commutation, that they're automatically eligible to vote?
Automatic, I guess, is a word that I take some quibble with, only because the state suggests that that's somehow problematic in some way. But yes, I do agree with the court that what the legislature chose to do in those Title II statutes is to say that if a person had received a full restoration of the right to vote, they can vote. And that's intuitive. The statute makes sense on its face. It's taking out from the class of people who would lose the right to vote those who have had the right to vote restored by a governor, or by a process, by the way, which is another pathway. So the two statutes can be in harmony with each other in the sense that 2-19-143(3) says that a person convicted of a crime in another state can lose the right to vote, does lose the right to vote, says that. But it goes on to have the exception for when full rights have been restored. That same exception exists for Tennessee citizens under 2-19-143(1). So again, what the legislature chose to do, Justice Bivens, is to recognize that an out-of-state conviction has consequences in that statute, but to simultaneously recognize or give full faith and credit to the notion that an out-of-state restoration of rights should be given full faith and credit. That was a choice the legislature made. So it's not easier for an out-of-state person. In fact, getting a full pardon, depending on what state you're in, that restores rights, can be a very arduous process and a very lengthy process. But Mr. Falls meets that test. He has received such a restoration of rights. He's not, I think the easy way to understand it is that he's not a person from whom a Tennessee statute takes away the right to vote. He is a full citizen. At the time he attempted to register, going to Justice Page's question, at the time he attempted to register to vote, he was a person with full rights of citizenship. And nevertheless, the coordinator of elections denied him the right to register. We brought this case to ask this court to rule that he does have the right to register to vote under the plain language, very plain language of 2-19-143(3). Again, I think if the court conceptualizes these statutes in harmony, 2-19-143(3) being a deprivation statute and 40-29-201 being a restoration statute, then the statutes are in harmony with each other. The state's position would suggest that somehow the passage in 2006 of a restoration pathway, it's just one pathway, but that the passage of a restoration pathway somehow repealed the exception contained in 2-19-143 for a person who's been fully pardoned. It does not do that. It could have perhaps attempted to do that. The legislature could have tried to change 2-19-143(3), but they didn't. And nothing in the text of either statute suggests that any position was changed. What happened is in 2006, the legislature adopted another pathway for voting rights registration, which is not one that Mr. Falls is legally obligated to follow. So for those reasons, Your Honor, we think that this court should reverse the Court of Appeals below and rule that Mr. Falls has all the rights of a citizen in Tennessee and is entitled to register to vote under the very plain language of the voting rights statute. And if the court doesn't have any other questions of me, I'll reserve the rest of my time for rebuttal.
Thank you, Mr. Harbison.
Thank you, Your Honor.
You may proceed.
May it please the court. My name is Alex Rieger, and on behalf of the Attorney General, I represent the official capacity defendants in this case, including General Skermetti, Secretary Hargett, and Coordinator Goins. And we're asking that this court affirm the judgment of the Chancery Court and the Court of Appeals. This appeal concerns the construction and application of 3 statutes, 2 of which create requirements for reenfranchisement for felons who lost their right to vote when they were convicted of infamous crimes. The state's position is straightforward here. If the text of each statute purports to apply to plaintiff, we apply it to plaintiff. So let's begin with the first statute. Tennessee Code Annotated 40-29-201 and its plain language. Its plain language says, the provisions and procedures of this part shall apply to and govern restoration of the right to suffrage in this state to any person who has been disqualified from exercising that right by reason of a conviction in any state or federal court of infamous crime. That's any person, any state or federal court, and any infamous crime. Since plaintiff's Virginia conviction for involuntary manslaughter meets all three, the provisions of 40-29-201 purport to apply to plaintiff and should do so. So then we move to the next statute, which is 40-29-202. Since plaintiff falls within the scope of 201's broad policy statements, the requirements of 202 apply to them if the text says it does. Part A of that statute says a person rendered infamous and deprived of the right to vote, deprived of the right of suffrage by the judgment of any state or federal court is eligible to apply for a voter registration card and have the right of suffrage restored upon, and then it lists conditions. So what are those requirements that the text says purport to apply to plaintiffs? A person rendered infamous and deprived of the right to suffrage by the judgment of any state or federal court, and plaintiff meets those. Plaintiff's argument here is that 2-19-143(3) operates as a disqualification statute that no longer applies to him because he meets the unless prong of that statute. However, that is the first trap and the first flaw in plaintiff's legal reasoning here. The end of disqualification is the restoration of voting rights. There is no space between. They are the same concept. There's no hair to split here, as plaintiffs would have you do. And how do we know that? Because the text provides for it. I'll point the court to a section of 143 that's been declared unconstitutional for violating Article 1, Section 5, as retroactivity provision. But if you look at that particular statute, which is 2-19-143(4), it says that the provisions of this section relative to the forfeiture and restoration of the right to suffrage, which means that each statute in 2-19-143 does two things. The first part, which is the part before the unless, disqualifies. The second part, following the unless, provides a requirement for restoration of the right to suffrage. We know that those can't operate alone because if you look at 40-29-201, the plain language of that statute uses the same language regarding restoration of the right to suffrage. So if you look at 201, it says, the provisions and procedures of this part shall apply to and govern restoration of the right to vote. Right to suffrage. It's just the exact same language as 2-19-143(4), which means that those statutes, by their plain and express language, cover the exact same subject matter and must be construed in pari materia with both to apply if one applies. This means that what the Court of Appeals and the Chancery Court have held is that there is only one construction and interpretation of all three of those statutes that allows all the words in each to be given some effect. And that is by construing, as Justice Kirby alluded to in her earlier questions, that because the statute is in shall not negative form and not positive entitlement form, you can construe 2-19-143(3) as creating a requirement. Now, plaintiffs, I'm sure, will come up during rebuttal and they'll say, well, it says, or, complying with the procedures of state law at the end of that unless. But we know that ors can be both conjunctive and disjunctive if the context requires it. And because we are required to construe 2-19-143 and the provisions of Title 40 in pari materia and harmoniously, the context requires a conjunctive or there. This also makes sense because it prevents the newer statute and portions of the newer statute from being rendered superfluous. We know that if there is conflict between the statutes, and again, the state's position is that both apply, both can be applied, and that the Chancery Court and Court of Appeals did so properly.
Does your interpretation require us to interpret or in the way that you're talking about?
Your Honor, I don't believe that it does. However, to the extent that the court believes that it does, the or can be conjunctive if it needs to be. Again, because it uses shall not, the state's position is that negative operation does not require the and to be construed conjunctively. But should the court find otherwise, the or can be held to do that based upon the context and the requirement that since the two statutes purport by their express language to touch upon the same subject matter, they both need to apply. And what the Court of Appeals and Chancery...
Mr. Rigger, this is Justice Lee. Is Mr. Falls restored to the right of citizenship by the Governor of Virginia?
I apologize, I didn't hear that.
Was Mr. Falls, did he have his right of citizenship restored by the Governor of Virginia?
Yes, Your Honor, I believe his clemency in that case, and I'll note that since it did come up during the principal argument for the plaintiffs, Tennessee does treat clemency and pardons separately. All pardons are clemency, but not all clemency are pardons, if that makes sense.
All right, so 143B references pardons and restoration of citizenship, but 4029-202, I guess A1, only references a pardon. So if Mr. Falls was restored the right of citizenship, that phrase, that particular designation is referenced nowhere in 202. So how could 4929-202 apply to him?
Your Honor, 202 can apply to him. Again, we recognize the issue that his clemency, his restoration of rights of citizenship is not the same as the pardon required under A1. However, he still has the outlet under 40-29-202A2, which provides expiration of the sentence.
But why would he need that when he could go under 143B, which refers to restoration of rights of citizenship?
Your Honor, because if he is permitted to use if the court construes 2-19-143.3 to be a purely restoration statute, which again, a purely disqualification statute, which again, Part 4 of that statute says it is not. But if that is permitted for him to proceed that route independently of the requirements of Title 40, that means we're ignoring the express policy language of the General Assembly and the fact that the text of those statutes purport to apply precisely to plaintiff. And
well,
that's something, I apologize.
You mentioned policy. Just in terms of policy, why would Tennessee deprive a Tennessean of the right to vote solely to allow another state to collect court costs, even though that state would allow the citizen to vote if he still lived there?
Your Honor, I believe that question is resolved by the Sixth Circuit decision in Johnson v. Bredesen. The state of Tennessee is fully permitted to create requirements to ensure that voters who have once demonstrated an antipathy towards the laws of the state of Tennessee no longer hold that particular view. And they can do so by ensuring compliance with court orders and child support as required by law.
But, I mean, is that good policy for Tennessee not to allow its citizens to vote because they might happen to owe costs in another state, and that has no bearing on Tennessee?
Your Honor, that question falls within the purview of the General Assembly. Again, Johnson versus Bredesen says that it is constitutional to do so, and provided that it is constitutional, the General Assembly is free to make that policy determination as per the separation of powers.
You don't have a view as to whether that's good policy or not?
Your Honor, I do not have a position on the policy of it other than that the General Assembly has enacted it into law, and that's what matters here. And again, as was noted earlier, allowing plaintiff to proceed purely based on 2-19-143.3 creates the additional problem of obviating the requirements of 40-29-202A and B for persons that have pardons, and that this construction violates the rule against surplusage, or I've heard it also called the rule against superfluity, because if we look at 1 and 2 of 2-19-143, both of those apply to in-state and out-of-state and federal court convictions when you look at all three of the first sections of 143. That's all of them. They all have primarily the same unless language, which includes a pardon. So why would someone who the legislature clearly intends has a pardon and needs to comply with the requirements of 40-29-202B, because he has the pardon as enumerated in A1 of that section, why would that even be necessary language if he can already use his right to vote card by an independent pathway in 2-19-143? One, again, this creates a problem because we're talking about an older statute and a newer statute. The state's position is that they can be construed harmoniously, but to the extent that the court is not convinced that they can, then any provision in the older statute, which is 2-19-143, must yield to the provisions of 40-29-201 and 202. What this means is that if the restoration portion of 2-19-143's three subparts steps on the toes of the restoration requirements in 40-29-201 and 202, the provisions of 2-19-143 that deal with restoration of the right to suffrage must yield. They must be elided, essentially, if there is conflict. Again, the state's position is that there's not, but if there is, old statutes must yield to new to the extent there is conflict. And Your Honor, again, the state's position is straightforward. Holding that 2-19-143 does not operate in isolation and creates a requirement using the shall not language, and that it is both, by its express terms, a disqualification and a restoration statute, means that the position and the judgment, the state's position and the judgment of the Court of Appeals and the Chancery Court are eminently correct. There is a harmonious construction. All three statutes can live peacefully, and that at the end of the day, plaintiff, under the rules of statutory construction, cannot escape the requirements of Title 40 that by their plain text clearly apply to him. And unless the court has any further questions, I will waive the remainder of my time.
Thank you, Mr. Rieger.
Thank you.
May it please the court, just a couple of closing points. Missing from the state's argument is any discussion or analysis of the Tennessee Constitution. Our Constitution chose to deal with the right to vote and place it at the forefront of the Constitution, and this court, in the Gaskin case, made clear that disenfranchising someone is not something that can be done in a self-effectuating way. It has to be done by statute. Taking away the right to vote can only happen by act of the legislature. Everyone is presumed to have the right to vote. That's the teaching of this court, it's the teaching of the Constitution, and it means that the state's analysis is backwards. The state's analysis starts with a restoration statute, 40-29-201, and says Mr. Falls meets the definition of someone who should be restored, so he has to follow that process. He's not someone who needs the right restored if he's not someone from whom the right has been denied. And the court should start the analysis with 2-19-143.3 to see whether Mr. Falls is someone from whom the right to vote has been taken. The time he registered to vote, he was not. On the plain text of 2-19-143.3. And had the legislature meant to change that statute, it should have done so, it could have done so directly and not obliquely, as the state is somehow suggesting here, that somehow the passage of a restoration process in 2006 implicitly changed the balance that the legislature had set when it, in 1981, when it passed 2-19-143.3, and then amended it in 1983 to add that you could also follow, another choice was to follow the restoration pathway in the restoration statutes. It contains exceptions. The pardon exception applies to Mr. Falls. He's not a person who's been deprived of the right to vote in our state. And that's the starting point and the ending point for this court. And we ask that the court reverse the court below and rule that Mr. Falls is entitled to vote in the state of Tennessee.
Thank you, Mr.
Thank you,
Harbison.
Your Honors.
We will adjourn until 1 o'clock. We have one more case.
All rise.